1968 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်300 MAUNG Brothers Burma Produce Trading Company Appellants First Burma Produce Trading Company Burma Produce Trading Company MAUNG Brothers Respondents ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစောမင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil First Appeal before ဦးကျော်ဆန်းဦး and ဦးစိန်သင်း Judges MAUNG Brothers Burma Produce Trading Company Appellants First Burma Produce Trading Company Burma Produce Trading Company MAUNG Brothers Respondents Contract Act Section 30 Bought and Sale Notes Contracts of what is known as forward sale whether of a wagering nature whether when the capital of the fund is out of all proportion with the transaction is sufficient to disprove the genuineness of the transaction, time lag between the first and the second contracts, whether entering into two successive contracts raise an inference that the parties did not at all contemplate delivery of goods. Hell, there is no doubt about the fact that the apparent tenor of the contracts as evidenced by the exhibit bought and sale notes were perfectly legal inasmuch as they were merely contracts of what is known as forward sale. They did highly savor of speculation in the rise and fall of the market, but the fact that the transaction have some of the outside features of gambling would not necessarily mean that they are of a wagering nature, and the question whether or not the agreements entered into between the parties are of gambling nature must be determined in the contents of the present day trend of trade and commerce, when highly speculative transactions are the order of the day. Vitessa First R. Company AIR 1934 NAC page 129 Ramniranjan Das Mahabir Prasad First Massa Bedtime Store BLR 1964 page 52 refer to. Although the capital of the respondents was just about 1 lakh, it was not impossible for the respondent fund to commit itself to several transactions involving several lakhs of money, because, especially in modern times, forward sales are frequent and ruling capital can always be raised far beyond the solid cash that a trading fund may possess. Therefore, this fact party is not sufficient even to weaken the case of the plaintiff respondent, much less to disprove the genuineness of the transaction. Khongyi Long Company Vest Loji Nanji 28 IA 239 ILRR page 107 distinguished. There was a time lag of nearly 2 months between the first and the second contracts, and there is also nothing to indicate whatsoever that at the time when the first contract was entered into, the parties had in mind execution of a subsequent contract. Therefore, the mere fact that the parties had entered into 2 successive contracts does not raise an inference that the parties did not at all contemplate delivery of goods. It was for the appellants to prove that no delivery was ever intended by the parties, for in order to decide whether there is a wagering contract, it is necessary to prove that there was a contract between the parties, that delivery would neither be taken nor given, and that the parties intended to deal in difference only. Muhammad Valley Patel Fest, the East Asia Tea Company Limited, 14, Run, page 347, Nanki Show, Fest, Lakshmi Narayan, AIR, 1954, Rajasthan, page 24, JH, Talk Lakshmi Das, Pashodam Das, ILR, 16, Boom, page 441, refer to Mr. C.A. Soma for the appellants, Wan Hope for the respondent, THEIN, Judge. The sole point for determination before us now is whether the agreements entered into between the parties, as evidenced by the exhibit ball and seal notes, fall within the ambit of Section 30 of the Contract Act, so that the plaintiff respondents are debarred from recovering the amounts due under them. This question arises under the following circumstances: in Civil Regular Suit numbered 228 of 1959 and numbered 798 of 1962 of the City Civil Court, Rangoon. The plaintiff respondent sue the defendant appellants for recovery of debt 7,750 and debt 17,625 respectively as damages. It was the plaintiff's case in the first suit that on 11 January 1956, they bought from the defendants 1,000 bags of MAPI, delivery to be made during the month of April 1956, that on 12 March 1956, they sold back the same quality and quantity of MAPI to the defendants at the rate of Jet 38.25 per bag, and that they were therefore entitled to receive Jet 7,715, being the difference in prices of the commodity transacted. In the second suit, the plaintiff's case was that on that February 1956, they bought from the defendants 715 bags of Tova at the rate of Jet 25.15 per bag, delivery to be made in all June, that the defendants failed to deliver the goods at the stipulated time, and that the plaintiffs were accordingly entitled to damages to the tune of Jet 17,625, being the difference between the contract price and the market price prevailing on the date fixed for delivery of the goods. The defense cited by the defendants in both the cases was the same. Their plea was that the transaction between the parties, being by way of wager, were void and unenforceable in law. An additional plea was also set up in the first suit to the effect that as the contract entered into between the parties was governed by the price fixed by the Grain Merchants Association, the plaintiffs were not entitled to damages contrary to the price fixed by that association. The learned trial judge, by his well-considered judgment, overruled the plea of the defendants in both the suits, holding that although the contracts under consideration were highly speculative in nature, they did not come within the purview of Section 13 of the Contract Act, he allowed the claims of the plaintiff. He, however, rejected the claim of the plaintiff for interest in the first suit from the date of suit to realization, and it was again this order that a cross-appeal has been filed. This cross-appeal, as well as those filed by the defendants against the decree passed against them, were, by consent of the land council for the parties, held together. This judgment of ours will therefore cover all the three appeals before us. We need only to repeat what has been laid down in various rulings of this court, that the law on this point is clear in that unless the parties to the contract intend at the time of entering into the contract that it should not be what it purposed to be, but that it should be a transaction which was to be settled only upon the difference between the price, the transaction does not amount to a wager. Mr. C.A. Soma, the land counsel for the appellants, spared no pains in referring to us a host of authorities in which the main theme was that in ascertaining the real intention of the parties at the time of entering into the contract, the court must probe into all the surrounding circumstances of the case. We have absolutely no quarrel with this proposition of law, and in fact, we find that this principle has been followed with meticulous care by the trial court in coming to its decision. There is no doubt about the fact that the apparent tenor of the contracts, as evidenced by the exhibit, bought and sealed notes, were perfectly legal inasmuch as they were merely contracts of what is known as forward sale. They did highly savor of speculation in the rise and fall of the market, but as pointed out in Vitessa vs. Arboin and Company 1, this is a normal feature of what is called forward contracts, which are essentially of a speculative nature. It is quite possible for not only the actual traders, but also outsiders to enter into such transaction with the hope of gain. Consequently, because the transaction bear some of the external features of gambling, there is no necessary inference that they are of a wagering nature. Furthermore, the necessity of construing such kind of contracts against the background of modern commerce has been stressed by Justice Dr. MAUNG, as he then was, in Ramnianjandas Mahabhaya Prasad vs. Massa Bedtime Store 2 in the following terms: times have changed since the first decades of this century. In those days, many men had cash, silver coins or gold sovereign to be tested for authenticity by ringing on the floor, and to be packed in candy bag for carriage. Today, money in higher commerce generally means check, notes or bank draft, letters of credit, and other banking guarantees, so that payments are often thus effected on paper. In the early days of this century, goods mean tangible things, and delivery mean the actual passing of these tangible goods from one hand to another. In this day, goods in the commercial parlance may mean title to them or the expedition of them, which may be passed from one holder to another, not by delivery of the actual hard goods, but by forward sales and similar transfer done on paper. Thus, the test as to whether a contract is real or whether it is only a wager must be applied in the light of the changed circumstances and practice of modern commerce. Therefore, the question whether or not the agreements entered into between the parties before us must be determined in the context of the present-day trend of trade and commerce, when highly speculative transactions are the order of the day. Another point which must not be lost sight of in deciding whether the contracts under consideration were lawful or not is the presumption in favor of the legality of a contract. This presumption, coupled with the provisions of Section 101 of the Evidence Act, casts a heavy burden on the appellants to prove the intention necessary to abrogate the contract. The intention to be proved must not be the intention of one party alone. It must be a common intention to bet. In other words, intention to gamble must exist in the minds of both the parties at the time of entering into contract. There must be a parallel meeting of minds to embark upon a gambling transaction. Thus, in Sukan 10 Fest, Food 10.3, it was observed that it would not be enough that one of the parties was known to be a speculator or even a gambler, as intention to gamble must exist on the part of both the parties to the contract. Mr. C.A. Soma, the legal counsel for the appellants, has frankly admitted that, in view of the principle mentioned above, his task was one of an uphill struggle, with plenty of odds against him. Let us now consider the point made by Mr. Soma in support of his contention that the contracts merely evidence gambling transaction. In connection with the contract for sale of 715 bags of tufa, it has been urged that this contract, along with similar contracts made by the respondent, involved inordinate sum of money out of all proportion with the capital at their disposal. It was alleged that the respondent capital was only just 1 lakh, whereas the volume of business entered into by him was worth more than 55 lakh. No doubt in the case of Kongji Long and Company Fest, Loji Nanji 4, it was observed that where the capital of the fund was a trifle more than 1 lakh of rupees, but the cost of goods contracted for would be that amount multiplied 500-fold. Although it was possible for traders to contemplate transactions so far beyond their basis of trade, it was unlikely that they contemplated completion of the transaction entered into. But in the present case before us, the cleavage between the capital and the cost of goods contracted for was not as wide as in the case cited above. Moreover, although the capital of the respondents was just about 1 lakh, it was not impossible for the respondent fund to commit itself to several transactions involving several lakhs of money, because, especially in modern times, forward sales are frequent and rolling capital can always be raised far beyond the solid cash that a trading fund may possess. We are therefore of opinion that this fact posse is not sufficient even to weaken the case of the plaintiff respondent, much less to disprove the genuineness of the transaction. Next, Mr. Soma made most of the fact that the rate of brokerage in respect of the sale of Tova was only 9 pias per bag, which according to the broker Chamsi Farsi, defendant witness 3, clearly indicated wagering nature of the transaction. In his deposition, Chamsi Farsi stated that the brokerage was 9 pias because it was a wagering contract. He was the person who acted as a broker in putting through the transaction, and his evidence was the sheet anchor of the defense, but the learned trial judge who saw and heard him has this to say at page 4 of his judgment. By a skillful cross-examination, this witness was shown to have made deliberate false statement in the course of his deposition, and it would be unsafe to place much reliance on his evidence when he stated that the suit transaction is by way of a wagering contract, which is the main burden of his evidence. It has always been the practice of the appellate courts that insofar as the decision depends on the credibility of a witness, they are always loath to disturb the finding of the trial court unless it is plainly wrong or manifestly unjust. This is the principle propounded in the case of Matan Shinvas Matan May 5, where it was observed that the judge who saw and heard the witnesses is in a much better position to form an estimate of the testimony than the appellate court, which has not this advantage. A picturesque version of this can be found in the following words of Viscount Sankey, L.C., which are quoted with approval in the case of Chinaya vs. Ukha 6. Witnesses without any conscious bias towards a conclusion may have in their demeanor, in their manner, in their hesitation, in the nuance of their expression, in even the tense of the eyelid, left an impression upon the man who saw and heard them, which can never be reproduced in the printed page. We do not therefore propose to discuss more about Chamsi Farsi evidence than to observe that his testimony is not such as to offset the heavy burden of proof regarding the real intention of both the parties to bet at the time of entering into contract. Mr. Soma had yet another string to his bow. He contended that in the case of the contract relating to Mapi, the respondents had never asked for delivery, but had only sold back the goods to the appellants at the higher price, which clearly goes to show that it was just to complete the wagering. We are, however, unable to subscribe to this view. In this connection, we would like to reiterate with respect what Nyabu Judge has said in Muhammad Valley Patel vs. the East Asiatic Company Limited 7 about such kind of contracts concluded under identical circumstances with those obtaining in the present case before us. The two transactions in the present case are in the nature of, firstly, a forward contract of sale by one party and purchase by the other, and next a contract of resale by the latter to the former, resulting in absolving the original seller from his liability to make delivery on the due date, and in absolving the purchaser from his liability to take such delivery, fixing the damages not on the difference between the contract rate and the market rate prevailing at the time of the originally intended delivery, but on the difference between the rate mentioned in the contract of sale and that in the contract of resale. The resale, which is set out in Exhibit B, was a resale which was brought about a month after the date of the original sale set out in Exhibit A, and they are therefore not simultaneous transactions, and the two transactions do not possess any prima facie evidence that at the time when the original contract mentioned in Exhibit A was entered into, it was the intention of the parties that the resale in Exhibit B was to be brought into being in any event. In the instant case before us too, there was a time lag of nearly 2 months between the first and the second contract, and there is also nothing to indicate whatsoever that at the time when the first contract was entered into, the parties had in mind execution of a subsequent contract. We would therefore hold that the mere fact that the parties had entered into two successive contracts does not raise an inference that the parties did not at all contemplate delivery of goods. It was for the appellants to prove that no delivery was ever intended by the parties, for in order to decide whether there is a wagering contract, it is necessary to prove that there was a contract between the parties, that delivery would neither be taken nor given, and that the parties intended to deal in difference only. Please see Nan Kishore vs. Lakshmi Narayan 8. The same view had been expressed in an earlier case of J.H. Top vs. Lakshmidas Purushottam 9, where it was laid down that the contracts are not wagering contracts unless it be the intention of both contracting parties at the time of entering into the contracts, under no circumstances to call for or give delivery from or to each other. The parties before us are grain merchants, and there is nothing on record to indicate that the respondent would have been unable to cope with the business had actual delivery been taken place. In the circumstances, we have no alternative but to hold that the subcontracts are not covered by Section 13 of the Contract Act. As pointed out by the learned trial judge, the appellants have also failed to prove the price fixed by the Grain Merchants Associations, and as such, we would also hold that the respondents are entitled to the damages as claimed by them. The only question that remains to be considered is the granting of interest from the date of the decree in Civil Regular Suit numbered 228 of 1959 till realization, which has been refused by the trial court. Payment of interest from the date of decree to date of payment is contemplated by Section 34 of the Code of Civil Procedure, but it is entirely within the discretion of the court either to allow or refuse the same. In the instant case, the trial court has given its reason why it thinks interest ought not to be given, and although we are not prepared to endorse them, to the full, yet we do not take them to be either perverse or unreasonable. In the result, all these appeals fail and are hereby dismissed with cause.